So last year, the Human Rights Council adopted a resolution, 3136. And this resolution does something unprecedented in the history of the Human Rights Council. It calls for the creation of a database of companies which in any way have any connection to the Israeli presence in the West Bank, including extremely indirect and attenuated connections. And the goal is to use this database for some kind of sanctions or other penalties down the road. The Human Rights Council, you can't hear me? Yeah. The Human Rights Council has never previously made any kind of database or list of private companies or in any way targeted or singled out individual private actors for any kind of investigation or censure. So this is quite a step the Human Rights Council has taken. And it says in the resolution that it is going to create a database of business enterprises which have directly and indirectly enabled, facilitated, and profited from the construction and the growth of the settlements. But that's not true, because the database the Council is compiling is not about companies that do business with settlements in occupied territories. It is actually about one particular geopolitical dispute, the Israeli-Palestinian dispute. And what we show in this report is that companies doing business in situations of belligerent occupation, situations with emplaced settler populations, is a worldwide phenomenon. And in conflict situations around the world, you find occupation, you find companies supporting that occupation, and you find the Human Rights Council doing and saying nothing. And indeed, in this report, we look at 4 such situations, and this is a non-exhaustive list. We look at the Moroccan occupation of Western Sahara, the Turkish occupation of Northern Cyprus, the Armenian occupation of Nagorno-Karabakh, and the Russian occupation of Crimea. That's not and we identify 44 companies which provide direct and substantial support to the governments and the settlement projects in those occupied territories. That's not an exhaustive list, this is just round 1, but we thought the report was long enough as it is. And what all these conflicts have in common is they have included massive human rights violations, massive displacement of people, and we find companies like Siemens, Credit Agricole. These are massively publicly traded companies. These are often companies with direct ties to their home state, often through the state holding a majority of shares, a large number of shares, or even putting people on the board of directors. And these companies are directly supporting these occupation efforts. Now, what has the Human Rights Council said about those situations, about companies supporting settlements in those situations? In none of those contexts has the Human Rights Council identified this kind of business activity as posing any kind of a human rights problem. They've never mentioned it before. So it's very surprising and strange to find in the context of Israel what the Human Rights Council has never regarded as a problem anywhere else in the world. All of a sudden it comes to regard as a problem. Now, this means one of 2 things are true. First of all, it could mean that whatever one thinks of the underlying political situations, whatever one thinks of the proper solution for these situations, it is not the case that business activity in cooperation or under the jurisdiction of a belligerent occupier is illegal. And that seems to be how the world treats it universally. And we think what this report shows is whether this action is ethically problematic, whether it's good for peace, it is not something that's treated as a human rights issue. And the Human Rights Council's deciding to treat it as a human rights issue in the context of one country only makes a mockery of the notion of human rights. Because what's human rights mean? Rights that people enjoy by virtue of being human. So if there aren't rights that one enjoys by virtue of being any human, be they Sawahari, be they Azeri, but are rights that can only be enjoyed in one particular political conflict, that's not a human right. And it makes a mockery of the Human Rights Council's mission. If, on the other hand, one still wants to think that this activity is legally problematic, then what the Council is doing now is completely outrageous. If it's the case that business activity in occupied territories is a human rights issue, how can the Human Rights Council investigate it in only one situation? It's the Human Rights Council. And of course, there is no pretense that the Human Rights Council will turn its attention to these other situations. I think it's useful to point out that amongst the countries who voted for the creation of this database are Morocco and Turkey, themselves the authors of massive settlement enterprises with strong links to foreign and international businesses. There's another aspect here. There are many people who are concerned about human rights who think it's a problem that the Human Rights Council pays too much attention to Israel, maybe, or doesn't pay enough attention to these other situations. But many people think, it's too bad about the Palestinian situation, and it's too bad about the Sawahari situation, and it's too bad about the Karabakh situation. But what I think this report strongly suggests is it's not that the Human Rights Council and the UN in general ignores Western Sahara, ignores Karabakh, despite their particular interest in Israel. It's because of it. That is to say, when you have a report like this, and we show the ubiquity of business activities in occupied territories, but at the same time, the Human Rights Council specifically says we're only going to look at one particular case that interests us. We see they're ignoring these other contexts because of their interests in Israel. What do I mean by that? The Council uses its focus on Israel as an excuse, as a scapegoat, to get out its human rightsy impulses. The reason it is not looking at Western Sahara and Northern Cyprus, Nagorno-Karabakh, they spent a whole day on Israel. It sucks the air out of the room. So even if one sympathizes with the Palestinian position, and the Sawahari position, and the Azeri position, the vast attention, resources, and unitary focus that the Human Rights Council is allowed to give this issue is one of the reasons that they don't pay attention to the other issues. It's not even a question of bias against Israel. It's a question of Israel at the expense of turning this into a universal standard. And I think anyone who cares about human rights as a universal standard, whatever their position on the Israel-Palestine conflict, their position towards what the Human Rights Council should be is, we totally support a database of companies doing business with settlements, but it has to be all settlements. Because once you narrow it down to one context, it doesn't mean you're going to get to the others later. It means you're going to get to them never. And that is what the Human Rights Council is doing. At the same time, they're creating a huge danger for companies around the world. Because the precedent that they are establishing with Israel is not going to be... They think that what they say about Israel, it's a special legal ghetto. What happens with the Human Rights Council, item 7, stays in item 7. However, that's not how law works. And different activists, Sawahari activists, Cypriot activists, Crimean activists, Azeri activists, are going to take the fact that they're creating this database and use it in various judicial challenges and challenges in corporate social responsibility fora against the many companies described in this report. So the UN is opening for itself a Pandora's box, the scope of which it can't really comprehend. I'm an international lawyer. I think I can... What would I suggest the Human Rights Council do? It's very simple. The whole point of law is to create a level separate from politics and morality that people with different views can agree on. So maybe people have different views on the Sahrawi conflict, or the Palestinian conflict, or the Karabakh conflict. But the notion of law is that we can agree on the rules that will govern all conflicts. You should be able to tell me what the rule should be before I tell you what the case it should be applied to. The Human Rights Council works backwards. They figure out the case that's being applied to, and then they make a rule just for that. The Council should not be allowed, the UN should not be allowed to operate under one set of rules for Israel. Whatever the set of rules should be, whether they be corporate liability for doing business in occupied territories, whether they be no corporate liability, which I think much better describes the actual current state of international law, there needs to be one law for everyone, because that's what law is. And if you have different rules for different entities, it's not international law, and it discredits the United Nations, and it weakens the possibilities of human rights. Well, that's it. I'm happy to take questions.
I would just also say Eugene is an expert on many issues legal issues related to the conflict. So if you have other questions outside of the scope of the report, I would definitely take advantage of him being here to ask your questions.
I thought it was very fair. Don't be shy. It's with my students in school, yes. Sir, can you please identify yourself?
Yes, I'm Manuel Rodriguez from American Association of Jurists. If I get your point, you're saying that this database created by the Human Rights Council should be used to the other cases, the other particular cases. Would you support a resolution in the main Human Rights Council to spread this methodology?
Absolutely. I would support a resolution that says if there's going to be a database, a database of companies doing business in what the Council regards as occupied territories, has to be applied to all such territories. Now, by the way, my prediction, that resolution would not pass. Because obviously Morocco is not interested. When Morocco proposes this about Israel, they don't mean that this should be an international standard. When Russia proposes that, supports these kind of things, they don't mean that it's going to be applied to Crimea. But certainly, I think that's the notion of law. And again, I might disagree with the Council on what is an occupied territory. But the United Nations has a series of resolutions about what are occupied territories. And a resolution that says we're going to make a list of such companies, that is articulating a coherent and intelligible principle. It happens not to be the one that I think is the current legal rule, but if they wish to move in that direction, that's their prerogative. But I think you'd be surprised how much resistance such a proposal runs into. But again, just to be clear, the resolution I would support is everything or nothing, not everything or something.
Eugene, could you speak a little bit about the European Court of Justice case that involved Western Sahara?
So I think there's been a view, there's been a concerted effort in the field of international law to create what I call a legal ghetto around Israel. An illegal ghetto is the creation of a set of rules that only apply to Israel, where Israel is not governed by, it's called a unique case, and is governed by a set of rules that don't apply elsewhere. And the European Commission has played a large role in this effort. They have a formal name for it. They call it a differentiation policy. And amongst other things, this involves various trade restrictions with certain Israeli companies. And they created a variety of rules. So, for example, they created a rule that Israeli companies operating in the West Bank their products must be labeled made in occupied Palestinian territories. So do they really believe that this is the rule? That if you operate in what the European Commission considers occupied territories, you have to be labeled occupied. So it turns out they don't believe that's the rule, because products coming from Western Sahara, Moroccan occupied factories and farms in Moroccan occupied Western Sahara, the European Commission specifically allowed to be imported labeled made in Morocco, despite the fact that the Commission regards Western Sahara as being occupied. Now, the Saharaui challenged this and various other European trade practices with Morocco. And they said it's a violation of your rules. And they said, why? Doing business in occupied territory isn't illegal. There's no legal problem with it. There's no legal problem with labeling something as being made by the government of an occupying power in an occupied territory. Now, that's the exact opposite of what they were saying about Israel. So they were saying one thing with Western Sahara, another thing with Israel, and they thought, great. We're going to have perfect acoustic separation. However, the Polisario did not accept that, and they brought a legal challenge in the European Court of Justice. And really, the Commission should not have had a problem with this challenge, because, as I said, based on international law, as I think as it generally stands, the Commission was well within its rights to label those tomatoes made in Morocco. And it was well within its legal rights to give Moroccan customs duties to products from Western Sahara. However, the Polisario walk into the European Court of Justice with all of the statements that the Commission has made regarding trade with the occupied territories, meaning Israel, what they see Israel is doing. And the Commission said, oh, this is different, Israel's unique. The European Court of Justice didn't buy it, because law knows no borders. And now the European Commission has found its trade with Morocco massively jeopardized. Now, if they had thought about that when they started implementing their practices with regards to Israel, they might never have gone down that road. But I think what's important to point out with this report is the legal ghetto is not, the walls of that ghetto will be smashed by activists like the Front Polisario. There are governments who are deeply interested in doing this. And so that's why it's important to proceed in a law-like manner. What's a law-like manner? Think, what is the rule that we can live with if it's generally applied?
One thing that might be helpful for people in the room, they may not know, there's so much focus on Israeli settlements, but if you could talk a little bit about the nature of settlements in these other situations. I know you wrote a paper last year called Unsettled, where you went through these various situations of occupation to talk about what settlements look like in these other areas. I'm probably 100% sure most of the people in the room have never even heard about it, so that would be great.
Okay. So the word settlements is uniquely associated with Israel, and it's unfortunate. As a matter, I'll tell you how uniquely associated it is. The word settlements is meant to refer to a provision of the Geneva Conventions, the Fourth Geneva Convention, Article 49.6, that says the occupying power shall not deport or transfer its civilian population into the territory it occupies. Many countries are of the view that Israel is an occupying power. But note that they're not called, so why are they called settlements and not deportation or transfer centers? Because if they were called by the language of the legal provision, deportation or transfer centers, people would say, who did the deportation? Who did the transfer? And in the case of the Israeli civilian communities in the West Bank, there was no deportation and there was no transfer. So the word settlements, the way it has come into the language, is it is a translation of the Hebrew term yeshuv, which means small startup town. There's a Hebrew word, yeshuv, it literally means settlement. So the international community uses a word borrowed from Hebrew to describe what is supposed to be a violation of international norm. No wonder the Cypriots and the Azeris have so little luck complaining about settlement practices in their territory. Unless you're going to use the language of the Geneva Convention, it's already, the bias is baked in. But there are many occupied territories around the world, and I've conducted a comprehensive study of them. And it turns out that in any situation of prolonged occupation, there has been a substantial and often purposefully directed movement of settlers into the territory occupied by the occupying power. As a matter of fact, one cannot find a prolonged occupation of contiguous territory where such a thing has not occurred. I think that's important to know. Now, very prominent examples include northern Cyprus and western Sahara. These were occupied by Morocco and Turkey, respectively, in the mid-70s. They've been declared occupied by the United Nations and by numerous other international bodies, not as often as that term has been applied to Israel, but this has been something that the United Nations has declared an occupation. In these situations, unlike the West Bank, the vast majority of the population now, are now settlers. So, for example, all of the Jewish population in the West Bank, in what's called the occupied Palestinian territories by the UN, would be maybe 10-15% of the population. In northern Cyprus, in western Sahara, it's the majority of the population. So there goes self-determination. Needless to say, the settlers in northern Cyprus and western Sahara have not been something that the Human Rights Council has ever thought proper to comment on, except in a few resolutions they once actually complained that the Republic of Cyprus was not affording certain privileges to Turkish settlers in northern Cyprus. So these are examples where the settlers have become the majority of the population. There are other cases, and northern Cyprus is also one of these cases, in which the settlement effort has been accompanied by an essentially complete removal or flight of the previous local people. Nagorno-Karabakh is one such example. So again, there are no Greeks in northern Cyprus. There are no Azeris in Nagorno-Karabakh. None of this happens to be the case in Western Sahara, in the West Bank, where everyone who was living there before is still living there. And so I think we see another way. So why don't we hear about these situations? I don't think we don't hear about them in spite of the attention that Israeli settlements get. I think it's because of Israeli settlements. That is to say, for countries like Morocco, for countries like Turkey, for these occupying countries, discussions of Israeli settlements are not a complement, they're an alternative. They're a substitute to discussions of the really important problems in occupied territories around the world. And I don't think one can get more attention for those other conflict situations without trying to balance the situation. Questions? Yes, in the back, ma'am.
Thank you from the U.S. mission. My question is, I see, looking at the book that you've prepared, that's been prepared, the naming of companies.
Yeah.
And I guess one of the issues we have had with the proposed database is this idea of naming and shaming companies or having a blacklist of companies. And it seemed to me that it goes beyond existing international law, in the sense that international law duties and obligations apply to states, and then states in turn are supposed to be regulating their companies. Mm-hmm. And so I'm wondering, in your proposal where you suggest that we should be doing a database for all occupied territories, do them all or nothing, in a conceptual framework of a database for all occupied territories, how would you envision the treatment of names of companies, and would your interaction be more with states directly, or in terms of reminding them of their duties, or how would you envision it? Thank you.
So we're a few steps ahead. Thank you very much for the question. The point of the naming of the companies in this report is not for shaming purposes. And I think we might, the most important part of this report is the introduction. I think we might make quite clear that the purpose of this report is to illustrate, I think, the point that one of the things this report illustrates is that the notion that such activity is prescribed goes far beyond current international human rights standards. Now, we could just say there are lots of companies doing business in occupied territories in a big way, but then who's going to believe us? So we're certainly not naming and shaming. We're using, by the way, material from the company's own statements, the company's websites. If anyone, I'd say if we're trying to name and shame anyone, it's the council for engaging in this effort, the countries that supported this effort, and any countries that might think of continuing to fund it, or I would even say continuing to sit in the council as they go down this one-sided path. I don't think, so in response to the early question, so would I support such a resolution? I would support it conceptually in that I would not criticize it as being biased, being one-sided, undermining the notion of human rights. I would think it would be, let's say, a massively progressive step in the development of international law. That is to say, going far beyond where international law is, but it would be conceptually coherent. And I would certainly support it as a political matter because I'll tell you what's going to happen to that resolution. It's going to be voted down, guaranteed. And I would it's going to be voted down, and I think that would further expose the kind of biased activity that the council is trying to conduct. Now, as to the particulars, if you're going to have a report, I agree. Even if you're to have a report that is international, the responsibilities for the enforcement of these norms lie with host countries, not with corporate general councils. And I think that's a very important point. I do think, as we note in this report, a lot of the companies typically, and this is also the case, of course, with companies doing business in the West Bank, they are doing so having gotten the okay, maybe not in a big public statement, but implicitly from their foreign ministries. So when we see a company doing business in such a territory, the assumption has to be that either their home country doesn't know about it, so tell them, or they know about it and they're okay with it, in which case the national obligation, that's how the national obligation is satisfied. And that is what we see today. So the report, the naming here is for illustrative purposes, but it also is to illustrate, I think, the magnitude of the consequences if what the Council is suggesting were to be taken as an actual rule of international law. So you can say, look, you can say two things. You can say either it's a rule of international law, in which case we're in big trouble, or you could say it is a purely one-off anti-Israel bias, in which case the Council completely discredits itself and should not be a place where self-respecting nations meet.
Could you speak a little more, Eugene, about the international law of business activities during armed conflict? Is that addressed in the Geneva Conventions? What is the status of international law right now?
Right, so I have a whole paper about this that was published 2 years ago in the Columbia Journal of International Law. The basic position was stated by the Security Council's legal advisor, Hans Karel, in an opinion in the 2000s. He was asked about the legality of business activity in Moroccan-occupied Western Sahara, and he said that we cannot identify any state practice that makes the conduct of business in an illegal territorial situation, in an occupied territory, in a non-self-governing territory, illegal. And that's what everyone always assumed the rule was, except Israel. Now, of course, there may be ethical concerns, there may be other kinds of concerns, but that is the Hans Karel opinion states the basic legal standard on the part of the United Nations.
And there have been some national court cases touching on this issue, so if you could just...
the Polisario have also been bringing cases in European national courts. Interestingly, there have been some cases in British and French courts challenging companies that are doing business in the Israeli areas allotted to Israeli jurisdiction under the Oslo courts in the West Bank, and those cases found that there is no violation. But I want to take more questions from people. Anyone in the room? More questions? I want to wait. I'm going to use this again because it's fun, but I'd rather take more questions. Yeah, ma'am.
There's something wrong? Oh, no.
Yeah.
Mary Lilling, International Council of Jewish Women. I've been going to many side events here during the Human Rights Councils, and there are more and more side events on nations under occupation. And I'm Kashmir, Tamil, Kurds. In your survey, how many nations under occupation have you listed? Have you
So
surveyed?
it really depends how you define occupation. I try to take a very narrow and strict definition so that people can't tell me you picked the wrong cases. So in the broader paper I've written, we look at about eight such situations. But there are more historically, and there's a question why certain things don't get treated as an occupation. So the UN does not recognize Kashmir as an occupied territory. That's a question to the UN. Tibet is not recognized as an occupied territory. But certainly the standards that are applied to create the notion of occupation in the areas of the Palestinian Mandate formerly occupied by Jordan, what we now call the West Bank, by those expansive standards there would be many more occupied territories in the world than are generally thought to be. Ma'am, you had a question in the back?
Yes, Keltumir from organization ISMON. First of all, I would say that I'm very delighted to attend this panel. I didn't expect to have such panel in this session, you know. And I would like to say thank you for paying attention and drawing attention to such important topic like this panel is dealing with. So my question is the following. Are you working in partnership with other organizations which focus on the same subjects than you?
No. So NGO Monitor has organized this event. We wrote this report, and we are not involved with any other organizations in the production of this research, because our point is not just about the specific conflicts. And our point is also a general one about the United Nations human rights system and the United Nations system. And you know, this is a research report. We understand that people interested in these various conflicts will be making use of it. Again, to the extent that people are interested in some of these particular situations, what I would stress is the relative lack of interest in them. There's only so much interest in this building, right? It's a finite thing. And if 99% is going to go to Israel, there's going to be not enough left for the rest of the world. And there are, you know, human rights supporters have a dilemma. You know, they know that the Human Rights Council is kind of preoccupied with Israel. It's a bit unseemly. On the other hand, maybe it does other good things. Maybe it can do other good things. Until it stops its preoccupation with Israel, it is going to be extremely. It's not going to be doing those good. It's not going to be doing those good things. One more question.
One thing, Eugene, that I'd like you to talk about before the International Criminal Court and Cyprus. You could talk about that issue.
It is the case that some of these territories that we described, Cyprus, Crimea, fall within the jurisdiction of the International Criminal Court. Cyprus has been a member of the International Criminal Court since 2002. Ukraine joined last year or 2 years ago. The Human Rights Council has suggested that businesses doing business in occupied territories may be committing war crimes, given that the companies involved, for example, in Northern Cyprus, involve major European firms, state firms. This creates significant potential exposure for complaints to the ICC from human rights groups involving these countries. Now, I don't think the Human Rights Council cared about that when they began its Israel database. But certainly, Cypriot refugees, when they see the council, if they see the council issue a database saying, look, these are companies doing occupied territories, war crime, they will quote that in submissions to the International Criminal Court. I think that's quite likely. Okay. Final questions, going once, going twice. I just want to do this once more.